What exactly is a trademark? Trademark is nothing but either some signs or a name or anything which actually distinguishes your goods and services from that of the others. You might have goods or you might just have services, and trademarks will distinguish these goods and services from that of the others. So you have a whole lot of goods in the marketplace. And how does the customer know that yours is the one that he has to buy? It is the trademark that will stand up and shriek and cry out loud to the customer, which will attract the customer to your goods and your services. That's the function of a trademark. For example, if we take the CocaCola trademark, the Coca-Cola trademark, if it is the Coca-Cola bottle for that matter, if it is kept in a bunch of beverage bottles, would stand up and you would immediately know this is the Coca-Cola bottle, the beverage, and you would immediately purchase that. And Coca-Cola is purchased for the value of the mark, the quality that it carries, the assurance of quality that it carries with itself. So the mark Coca-Cola actually identifies that beverage and tells the customer that this beverage comes from the Coca-Cola company, and the purchaser of that particular product would have an assurance of quality which always comes with that product. Same is the case with BMW, or for that matter Lycra, or any such mark, for example Bajaj, or for that matter Tata. The word trademark is defined quite similarly in Europe as well as in US. In Europe, for example, the mark is defined as something which might consist of words, designs, letters, shape, numerals, such that it distinguishes the services and goods of one product or one user from the other. What can be a trademark? This could be a question that always arises. What is it that can be a trademark? It might be a letter, it might be a number, it might be the name of a real person, it might be a fictional name, it might be a mythological name, or a historical name, or a geographical name, or a common name, or a word without any meaning. Any of these could be a trademark. For example, Walt Disney. Walt Disney, did you know, was the name of a person? And that was the name it was given to a particular cartoon character. And a character was created, and that's how this whole mark was identified. Or for that matter, you have words which have no meaning at all. Yaris, Omo, Alvar. These are words which have no meaning at all. Or it could be a logo, like the logo of the European Patent Office, or the logo of Nike, or if you remember the logo of the Tata, or if you remember the logo of the Birla. So these are all logos of the sun, Aditya Birla, the sun. So these are all logos, and the moment you see the sun, you identify it with the house of the Birla. Even the shape of goods can be a trademark. Something like the Tanqueray bottle, or for that matter, the Toblerone chocolates, the Gems chocolates. Toblerone chocolates, if for example, you just had the Toblerone chocolate on the table, the triangular shaped chocolates on the table, one would immediately know that these are Toblerone chocolates. You don't need the label, you don't need the packaging for anyone to tell you that these are Toblerone chocolates. That's how they have been made for a very long time. So therefore, what has happened is, the shape of those Toblerone chocolates has acquired the status of a trademark, or for that matter, gems. Gems is something we all have grown up with. So if you have a bunch of colored chocolate in front of you, one would immediately know, oh yes, this is gems. So with the product, you're able to relate it to the mark. That is the function of a trademark. So when the shape of the product, the packaging, starts functioning as a source identifier, it becomes a trademark by itself. Take for that matter the product design of a Merc, of a car, or for that matter the Tide, the detergent powder, or for that matter the packaging. Now look at the packaging of the Pringles or for the CocaCola cans. The moment you see these cans, you can immediately identify, oh yes, this is Pringles, oh yes, this is Coca-Cola. For that matter, if you see the Coca-Cola shape, the bottle of the shape of Coca-Cola bottle, one would immediately identify that yes, this is the Coca-Cola bottle. This looks like a Coca-Cola bottle. This is the Coca-Cola bottle. So from the shape and the packaging, when the user is able to understand that this is identified with this particular mark, then that packaging, that shape starts functioning as a trademark. For such a thing to happen, of course, there has to be a long use. The moment you start using it for a very long time, people start understanding and identifying, the consumer starts identifying your goods with your trademark, and therefore that particular shape by itself acquires the status of a trademark. For example, if you take a bottle, if you have Nimbu juice, and let's say it is sold in a container which looks like a lemon, and everyone is purchasing this new lemon juice in the market. Certainly, people will start looking at that yellow color in bottle and immediately start identifying it with your brand. So in such a case, the shape starts functioning as a trademark. So shape has acquired the status of a trademark. Sometimes even color can act as a trademark. For example, for McDonald's, N. The moment you see that N, yellow color N, one realizes that here is a trademark, here is a McDonald's outlet. So in such a case, the shape, the color is performing the function of a trademark, and therefore the color acquires the status of a trademark. Again, for color to acquire the status of a trademark, it requires long use. Or for that matter of sound, the sound can acquire the status of a trademark. From far, if you hear the starting sound, the music of windows opening, one realizes, oh yes, a laptop is opening or a computer is starting, it is Windows which is operating. One wouldn't mistake it for anything else because that is very unique. So such a sound, for a sound to acquire the status of a trademark, it requires time. People start recognizing Windows with the sound, associating Windows with that sound, and therefore such a sound also acquires the status of a mark. For that matter, the Harley Davidson bike, the moment the bike starts, it gives a particular sound. That again marks the fact that this is the Harley Davidson bike. So again, sound starts functioning as a trademark, and that sound can be used as a trademark. Of course, in many cases, you don't always use the sound as a trademark. You use the sound in addition to your own trademark as such. For example, in the case of Harley Davidson, you have the name Harley Davidson, and you also have the sound. So sound is an adjunct. It may not be the only mark, but as an adjunct, the moment you hear that particular sound of the starting of the bike, you identify it with Harley Davidson. So as an adjunct, the main trademark, it will also get elevated to the status of a trademark by a long use. And sound can be characterized by certain signals, certain graphical signals. So therefore, sound can also be used as a trademark. Sometimes smell can also get elevated to the status of a trademark. For example, you have the smell of fresh lemon or the smell of vanilla. So vanilla ice creams can be identified with that smell, and therefore smell can acquire the status of a trademark. Many times slogans are used as a trademark. Slogan which may be a catchy one-liner like "Yehi hai right choice baby," McDonald's "I'm loving it," or "Lage raho," or "GLL chai, raha na jai." All these are slogans. So when you actually start your business and when you have a trademark, you may also have a slogan as your trademark, and you may have different slogans for different products. And these slogans, by being used over a period of time, would arrive and be elevated to the status of a trademark, because people would start recognizing that particular slogan with your mark, with your goods and your services. Another class that has now recently been added is the service marks. Now there are a lot of service industries like software, educational institutions, or research companies doing especially only research. So these are services, or there may be technical consultancies, or there may be legal services. All of these are also identified by one trademark or the other. Now, the Trademarks Act has included a specific class, a specific category of mark, which is called a service mark, in which all of these services are included. For example, the University of Delhi. Now, the University of Delhi is engaged in educating students. It runs classes for students, it educates students, it gives them various degrees in the fields of science and various technology, and it has a mark of its own. It uses a logo of its own. The name of the university is the University of Delhi, and it has a specific logo, which is what I have pointed out here. This logo of the university can be specifically registered as a service mark. Same way we have the Dental Council of India. Now the Dental Council of India controls, regulates the practice of doctors in the dental practice. They also have a particular mark. Now this mark can also be registered. This logo can also be registered. There is a reason why we do need to register these trademarks and these logos. Not that another dental council will be started and they may use this, but just that this is unique to the dental council. And in the event anyone else in the dental field or in the medical field was to use this particular logo, then people would be deceived, people would be confused, and to avoid such confusion, it is necessary to register the mark. Once the mark is registered, and if there is any such use, misuse by any other third party without the consent of the owner, then any legal action can be pursued. Registration is not a must, we will come to that, but registration is good, is recommended in order to protect your mark.